In the first part, I alluded to the issue of whether the justice is blind and the discrepancy between the culture on the street, the culture in the home, and culture envisaged in the Anglo-Saxon law system. Let me give you an example. In a household setting, if a child has done something wrong, something nasty, he has broken something or he has done something, beaten somebody or brother or sister or something, if he confesses to his wrongdoing in a manner which shows remorse, the parents tend to appreciate his conduct. However, if the same child, when he grows up, and he grows up to above 18 years of age, and he does the same thing in a court of law, he will be punished, and the punishments are very long. So there is a clear discrepancy between what is taught to a child and what actually happens to him. One of the things of which I am a great proponent is that we teach the next generation, the children in colleges and schools, everything about Aristotle and everything about Bernard Russell and this thing and that thing. But we don't have a subject in which they should be taught as to how to conduct themselves in the society, how to write a check, how to deal with a legal case, how to confront an assault, how to respond to a derogatory remark, and hundreds of small things which are of everyday occurrence, and which, because he does not know how to respond to it, even though he may be a very educated person, basically ends in trouble, the brawl in the society, increased litigation, and so on. So it is quite important that either we tell the children about the things in the real world and what can happen to them, or we have to else alter some of our attitudes in granting, in giving punishments, or so on. Then again, there is a problem. It is not very clear in the 14 to 18 years age group that how the law would really, in actuality, deal with the various issues of crime and imprisonment, potential imprisonment, and so on. In a country where record keeping, although it is not very recent, the birth and death certificate system is more than a century old almost, but still the thing is that its comprehensiveness, its reliability is not the same in rural areas and in urban areas, and even within the urban setting in various population groups. This results in a problem of the age, and it also brings the services of the radiologists into the legal system. I remember a case in which one of my lawyer friends asked me, have a look at this report. And that report was from a hospital near the capital, not itself in the capital. And it was a case of rape, and in which a woman was claiming that she has been raped about 4 months back and she has got pregnant or something like that. And this report seemed to indicate that the age of the fetus is 6 months. But on close examination of the report, it was very, very clear that the picture which they showed of the measurement is not the pose of the head which is used in measurement of gestation age, but a pose which would definitely give a much larger age and which is not a valid pose to get the age from. So it basically meant that this was an attempt to prove that the fetus is 6 months old and the incident and the claim of the woman is false. And I asked the liar how much fee he has taken. He said that he has taken 20,000 rupees for this case. I said, well, you know something, because this report has got this problem and it is your own client and you are relying on this report, uh, you might save the male which he was representing, but you know the social consequences of who will take care of the boy for the rest of his life for your 20,000 rupees. Now I gave him one or two other advices, and from that onwards, the liar friend, he used to avoid me, confronting me in anything. So instead of science being used to document the crime and to enhance the evidence,